Hello everyone, welcome back to my channel. This is Ashwini from Sri Venkateshwara College of Engineering. So today we will be seeing about the topic of patentability. So what is patentability in IPR and RM? So first let us see what is patentability. So this criteria of this patentability is one of the most important parts of patent law. It affects how effective the patent system is overall promoting scientific and technological advancement, economic expansions and public good. If we will fail, patent systems will also fail. So the patentability standards and their components are not grouped under Indian Patent Act. Although definitions provide high level understanding of this criteria, it takes longer than anticipated and ascertain the details of some requirements. So these requirements of this patentability is one of the most crucial elements of this patent law. They will serve the basics for the grant for patent and scope for the protections and its valuability. So it affects how effective this patent system is at promoting innovations, science, and technological economic expansion and societal goods. If they will fail, so the patent systems. The Indian Patents Act does not organize the standards of patentability and their components. Despite of these definitions capturing the criteria at high level, it takes longer than the anticipated that determines some of the needs. So, the innovation of this is satisfies the requirements outlined by the United States Patent and Trademark Office to qualify these patent product protections, and it is said to have the patentable subject matter and also referred as patent eligibility. So, to qualify this patentable subject matter, the invention has to satisfy two criteria. So, that is statutory, judicial, the subject matter of the innovation must fall into the category of process, machine, manufacture, composition of matter. Second, subject matter cannot fall within the exceptions recognized by the courts, namely laws of nature, physical phenomena, and abstract ideas. Some of the examples of these patentable subjects may include business methods and process, computer hardware, machines, sports equipment, electronics, pharmaceuticals, fabrics, fabric designs, computer software that produces useful concrete and tangible result. So as per 3 and 4 Indian Patent Act, the following innovations of patent is in India. An innovation of this phrase or trivial, the invention of this claims anything obvious contrary as well as the established natural laws. The mere discovery of scientific principle. Moreover, an invention whose primary goal or intended use is contrary to the law of morality, that is injurious to public health. The formulation of an abstract theory for the mere discovery for the new form of substance which does not result the enhancement of known efficacy of this substance. So, this mere discovery of new property or new use from known substance, mere use of this known process, machine or apparatus useful such as known process result, new product employs. So this substance of this obtained mere admixture resulting only for the aggregation properties of the process producing such substance. So the three basic parameters of an invention of patentable are nothing but it must be new, which means it cannot be already be found. It must be non-obvious, which means even someone is extensive knowledge of the subject matter could struggle to come up with the invention without extraordinary effects of maintainable proofs. First one is criteria of patentability. To be eligible for this patent, an invention must be device or process that patentable subject matter. This phase of patentable subject matter was lifted portable to the user patent code but did not occur anywhere in the Patent Act. So, the types of this agreement uses the phrase patentable subject matter. Some of the requirements of this principle of patent law is nothing but the invention that must be original, unrelated to any previously published work or marketable goods. The normal invention that defined in the Section 21 of Patents Act 2005 is one of the most anticipated by the former publications, and it is not in the public domain. This invention must not have been published before. However, the discovery alone does not qualify as an innovation. So in this case, the Vishnu Prasad Radhe Shyam v. Hindustan Metal Industries have acknowledged these two requirements for granting patents: novelty, utility that were crucial. Gopal Glass Works Limited, assistant controller of this patent, made this observation: the innovation must be novel, original, in order to be patentable. The standalone novelty itself is not a complete criterion, but the product or invention must be sufficiently original as well. Second is non-obvious or incentive steps. So according to these sections of Indian Patent Act, any product or process that involves in the invention step and it is capable of being used in the industry is called as invention. So this definition makes it clear that the invention must have been inventive steps and also must be known to be any skilled person in a particular field. So they are skilled person that must identify the inventive step in the form of prior use, art and knowledge. He must be able to tell difference between the subject matter and the invention. Consideration must be given to the observing of these differences and must be a degree of invention. So these were some of the authors you can see who have come across these inventive steps. So infringement comes under this. So this fact of infringement is the invention of patentable or even patented does not necessarily mean to use the invention that would not be infringed in another patent. So the first patent is given in the area that might include the claim covering this criteria. So this means that the later inventor must obtain the license from the earlier inventor to be able to exploit their invention. So at the same time, the earlier inventor might want to obtain this license from the later inventor, particularly if later invention represents a significant improvement in this implementations. Conclusion is intellectual property includes any production, invention, idea, or artistic work outcome for the person, minds who rights granted for this individual into creation, work, idea, or invention that is known as intellectual property rights. So this is the conclusion of this patentability. Thank you for watching my video. Please do share it to your friends and families.